Good morning everyone, and thank you all for attending this morning's webinar on the organisation of working time. In my mind, this is probably one of the most important pieces of legislation that employers need to be aware of and need to adhere to. So it is a good webinar. Hopefully you will find it hopefully you'll find it useful. My name is Laura Murphy. You're probably familiar with me on these. Today I'm also joined with my colleague Jenny Huzzy, who'll be popping in and out as well with some of the stages. I have to apologise, I have a bit of a cold, so pardon if my voice is a little bit muffled or unclear. But we'll crack on anyway, and hopefully, as I said, hopefully you'll find it useful. So, as I said, I think this is one of the most important pieces of employment legislation out there, and it really is a huge piece of legislation. So today we're going to look at, I suppose, some of the more notable areas that are included in it, and the areas that employers tend to face a lot kind of on a day-to-day basis. So we'll look at maximum weekly hours, we look at rest breaks, lunch breaks, we look at holidays and annual leave, we look at public holiday entitlement. We quickly then, before we finish up, we'll just look at Sunday working and night working very briefly as well. So we'll go through each one of these, each one by one, and then always, as always, we'll have a question and answer session at the end. So hopefully today, I think the webinar itself will be quite short, but we leave a lot of questions, a lot of time for questions at the end, and then please do put forward your questions, because this is often the time where we get some kind of good communication going, and it can be almost the most interesting part of the webinar, I think. So yeah, feel free to ask your questions. Just before I really kick off, I just came across this stat when I was doing some research. This is a stat from NERA. Obviously NERA are now the WRC, but in 2014 NERA had a helpline, and of their calls that they received, the majority, so 21%, the majority of calls were in the area of working time and working hours. So again, I think that reflects kind of that this is a kind of an area of concern, or maybe an area of confusion for employers. So if you have concerns or you are a little confused, you're not alone. A lot of other employers are as well. So we just thought that was an interesting stat to kick us off, I suppose. Moving on then, if we look at who the rules apply to, the Organisation of Working Time Act, it was established in 1997 as a protective legislation for all employees. So all employees, whether they're full-time, part-time, a casual worker, apprentice, an agency worker, basically anybody who's under any sort of a contract of employment with you, or an agency worker or an apprenticeship, so it's really most employees you'll find that this applies to. There are very few exceptions. I have listed the exceptions here for you. So it's the guards, anybody working in members of the defence forces, people who choose their own hours, probably namely here we're talking about self-employed people, and then family members on farms or in private homes. So as you see, that the exceptions are quite limited, and who it does apply to is quite wide and varied. So chances are this legislation is applying to you and your employees. There are some other minor exceptions to specific parts of the legislation, and we'll touch on them as we go through today. The first area that I want to look at is the maximum working week. So the maximum working week, it's 48 hours per week. So employees cannot work more than 48 hours per week. However, this can be averaged out. So it doesn't have to be, they can work more than 48 hours in 1 week if it is averaged out over a period of time. So the question is then, what is that period of time? How much can you average it out? So for most employees, you can average it out for over a 4-month period. In some cases, it can be averaged out over a 6-month period. And where we're talking here is generally security industry, hospitals, prisons, agriculture, or people who are working in businesses that have peak periods, perhaps tourism. And then finally, in some exceptions, people can average it out over a 12-month period. This is really by collective agreements and generally has to be approved by the Labour Court. Inside this, when we're talking about the calculation of the 48-hour week, and when we're counting it and totaling it, we don't include breaks or lunch breaks or annual leave, because obviously that's not working time. So that there are some mitigating circumstances when we talk about the 48-hour week. And my colleague Jenny is just going to jump in here and clarify them for you.
Okay, so the mitigating factors, generally you have the likes of double employment. So it is the employer's responsibility to ensure that you're not employing somebody who's working elsewhere and that the total sum of their hours won't exceed the 48 hours. There's an obligation on employers, therefore, to establish if any employees have second employments and to establish how many hours are being worked in these second employments. The total hours worked across both employments should not exceed the 48-hour average weekly specified in the Act itself. So to manage this, we recommend that as part of the employment contract, you do include a clause obliging employees to inform you if they're working elsewhere. And if an employee notifies you that they're in employment elsewhere, they should fill out a double employment form stating how many hours are being worked in the second employment. And also employers should make employees aware that they are obliged to inform the employer of any changes to these working patterns, so as to ensure continued compliance with the Organisation of Working Time legislation. Another mitigating factor then would be if you have people on call or on standby. So if you have an employee who is on call or on standby, the prime determining factor is whether this is working time or not will be the requirement to be at a particular place, or not. If a physical presence is required, it's considered working time. If not, it's not considered working time, even though you may, like a doctor, be on call. Another mitigating factor then would be workers with no fixed place of work. So following a recent decision by the European Court of Justice, where workers have no fixed place of work, the time they spend travelling between their home and their first and last customers is to be considered as working time. I'm sure you'd remember this was a huge case in Spain last year. Mobile workers may work up to a maximum of 60 hours in any single week, so long as their average weekly hours over the review period does not exceed 48 hours. Okay, and then under the age of 18. So working for people under the age of 18 differ from those that we've listed here. Under 18s may not be employed for more than 40 hours a week or 8 hours a day, except in a genuine emergency. The maximum weekly working hours for 14 and 15 years is lower again and will depend on whether it is during term time, whether it's a holiday work or work experience. So with regard to under 18s, there's a number of different requirements on employers. If you do employ young workers, or if you're considering employing young workers over the summer, there is an online guide summarising the main rules. The Department of Enterprise, Trade and Employment issue it, and we would recommend that you have a look at it. If you are a Bright Contracts customer, we do provide users with support on this matter as well. There's a number of exceptions. We spoke about some of the roles that are exempt, but in addition to these, there are separate regulations governing the working time of trainee doctors and employees working at sea. Okay, so rest breaks at work. An employee must receive a 15-minute break after 4.5 hours worked. 30-minute break after 6 hours worked, which can include the above 15-minute break. Rest breaks should not be given at the end of the day, so it's not a case that somebody can leave early and take into account the rest breaks. There's no requirement for rest breaks to be paid, as breaks are not considered as working time. Okay, there are special provisions governing the daily rest breaks for retail workers. For any shop employee whose hours of work include the hours from 11:30 a.m. to 2:30 p.m. and work more than 6 hours, the minimum duration of the break shall be 1 hour. The 1 hour break should take place between the hours mentioned and cannot be granted at the end of the working day as previously mentioned. Okay, so your daily rest breaks then. Under the legislation, an employee is entitled to 11 hours consecutive rest in each 24-hour period. This effectively means that having completed a day's work, an employee cannot report back to work until 11 consecutive hours have elapsed. Your weekly rest periods, an employee is entitled to a period of 24 hours consecutive rest in each 7-day period. This period can be averaged over 14 days. These are just the minimum weekly rest periods legislated for, and of course there's nothing to prevent employers providing longer weekly breaks. There are a number of exemptions when what we've mentioned above, the rest periods do not have to apply. So they include shift changeover, a split shift, unforeseeable circumstances or emergencies such as the power going out. There's also exemptions in place for dock or airport workers, security workers, workers of transport services, for example, train drivers, train technicians, ambulance and fire workers, people working in the media, radio, television, etc., and seasonal workers. All these exemptions are subject to equivalent compensatory rest being made available to the employee. And in these circumstances, rest may be postponed temporarily and taken within a reasonable time frame. That basically ensures that although the employers may operate a flexible system of working, employees must not lose out on their actual rest. Okay. The appropriate protection for justifiable reasons, an employer cannot provide compensatory rest. The employer must make adjustments to the employee's conditions of employment in order to compensate the employee. What exactly constitutes appropriate protection is not specified. However, it cannot mean the granting of monetary compensation to the employee, the provision of any other material benefit to the employee other than benefits or amenities that would improve the physical conditions under which the employee works. This can be taken to mean that the use of vouchers or presents will not be allowed. Some examples, which are by no means exhaustive, of what might constitute appropriate protection have been provided. These could be refreshment facilities, recreational reading material, facilities, amenities such as television, radio, music, alleviating monotonous work or isolation.
Yeah, and I'll just actually jump in on that slide there, Jenny, because I suppose when we talk about these appropriate protection for, when it's not possible to give a compensatory rest break, I suppose the obvious example, and the one where there's been cases about it, is in the security industry, where we had Newton Services against an employee because they weren't able to provide breaks for the security guard because they needed him on site for the whole duration of his shift. So what they had done was they provided, again, similar to what Jenny has just said here, refreshment facilities, and TV, internet access, input where he was, and the courts ruled that that was a sufficient appropriate protection for him in relation to his compensatory break periods. So just actually to finish off there briefly before we move on, it's really important to notify your employees about their working hours and their lunch entitlements, and to notify them in the correct manner. So under the terms of the Employment Act, hours of work and rest periods must be included in the contract of employment. And again, this highlights the importance of having your contract of employment in place. Where your hours differ from week to week, and it's not possible to insert those hours in your contract of employment, you must inform staff of their hours at least 24 hours before the first day of the week that they're required to start. Of course, exceptions are permitted to this. So basically, this provision to give advance notice does not affect your right to require the employee to work different hours other than those originally notified in unforeseen circumstances. So if somebody is running on sick and you need to call somebody kind of last minute to come in and cover, that's perfectly fine. I suppose what the courts will look at, if that's happening on a regular, reoccurring basis, then there's going to be question marks raised and questions there. But if it's on an ad hoc, kind of in unforeseen cases and unforeseen circumstances, then that's perfectly fine. What I would say, what the important thing is, that you do keep records, so that you have a record of how you've notified employees of their break entitlement, and that you've notified them what to do if they don't receive their break entitlement. And this would generally be that if they don't receive their break entitlement, they must inform a manager. I would generally suggest, again, that that's put in the contract of employment, and you can just include it in there, and that's in, and you've notified your employees from the start. So that's just the key thing there around notifying employees.
Okay, so we'll take a look now at holidays, public holidays, the organisation of working time legislation for both of these areas. The Act sets out the minimum entitlements for both, which we're going to look at, but just to be aware that an employer may also decide to award additional annual leave at their own discretion. This is often referred to as non-statutory annual leave. However, as with any discretionary benefit of employment, you must take care to ensure that equality and fairness in the provisions of these benefits is being provided for. So as such, we would advise that you do include an annual leave policy in your company handbook. So your annual leave entitlements, there is no qualifying period for holidays, and all employees with hours worked, regardless of their status or service, qualify for paid annual leave. Your holiday entitlements should be calculated using one of the following methods. So the first one being 4 working weeks in a leave year in which the employee has worked at least 1,365 hours. 1/3 of a working week per calendar month that the employee works at least 117 hours, or 8% of the hours an employee works in a leave year subject to a maximum of 4 working weeks. Now, the thing to bear in mind in here is that if one or more of these methods is applicable, the employee is entitled to whichever method provides the greatest entitlement. And these methods of calculation are only for the statutory annual leave entitlement. As I mentioned there a minute ago, the employer may decide to give over and above the statutory entitlement. So just as an example, if we look at Joe Blocks, so he works Monday to Friday, 9 a.m. to 6 p.m., 40 hours a week. On week 10, he wants to know how many days holidays he's got due to him. Okay, so what we're looking at here, 40 hours a week by the number of weeks gives a total working hours of 400 hours. If we multiply that by the 8% rule, so 8% of his total hours worked to date gives him an hourly holiday entitlement of 32 hours. If we want to break that down to the number of days, we divide that by the number of days he actually works in a normal day, and that entitles him at this stage to 4 days holidays due. The second example then, so Josephine works a 4-day week, she's paid a monthly salary, and at the end of month 6 she wants to know how many holidays she's entitled to. So in this regard we're looking at the 1/3 rule. So 1/3 of her normal working week, which in this case is 4 days, gives her a monthly entitlement of 1.33 days. Multiply that by the number of months she's worked so far, which gives her a total entitlement of 7.98. In most cases, most employers will round that up, but you might have a few who won't. So just those examples, if you work a 5-day week, the 1/3 rule is 1.66 days per month. That's your statutory 20 days. If you work a 4-day week, it's 1.33 days per month, which gives you the entitlement of 16 days per annum. Or if it's a 3-day week, it works out at 1 day per month, and that's an entitlement of 12 days per annum. Okay, so your annual leave entitlement. What to include when you're actually looking at what employees are entitled to. Time spent on annual leave, any protected leave, so maternity, adoptive leave, and at some point this year, paternity leave. The employer has to look at any parental leave, force majeure, certified sick leave, and or the first 13 weeks of carers leave. Okay, annual leave is not accrued on temporary layoff or career break. Now, certified sick leave only came into effect from the 1st of August of last year with the introduction of the Workplace Relations Act. Prior to that, certified sick leave was not brought into calculation for the entitlement to holidays. It is up to the employer to decide when the holidays are to be taken. So obviously it would be the employee that requests that they go on a certain amount of time, but the employer has to take into regard work requirements and subject to his or her taking into account the need for the employee to reconcile work and any family responsibilities, but obviously make available the time for rest and recreation for that individual. It is the responsibility of the employer to ensure that the employee takes their full statutory leave within the proper period. Generally, the holidays must be given to the employee within the leave year or with the employee's consent within 6 months of the following leave year. The employee may, with the consent of the employer, carry over holidays in excess of statutory minimum leave. And then the employer must compensate the employer for any unused annual leave that was accrued during the year in which the employment ceases.
I think that's just to come in there. I think that's an important point at the end. You can compensate an employee for unused annual leave only when employment ceases. So in any other event, it's not acceptable or allowed or permitted to pay employees for annual leave.
Okay, so just take a quick look at the actual calculation of annual leave. If the employee's pay is calculated by a time rate, let's say an hourly rate, a fixed rate or a salary, the amount paid for 1 week of annual leave is equal to the amount paid in respect of a normal week. If the employee's pay is not calculated by a fixed rate or salary, the amount paid for 1 week of annual leave is equal to the average weekly pay of the employee calculated over 13 weeks prior to the holiday leave commencing. This is to include any regular bonus or allowance that does not vary in relation to work done, but it does exclude any pay for overtime.
Yeah, I'm just going to come in because that's a good point, because it should include any regular bonus, because ultimately the annual leave is there to allow employees a rest period, and they in no way should be at a disadvantage for taking annual leave. So if they do receive a regular bonus, that whether it's a regular commission payment, that should be included then as well in their payment.
So moving on then to public holidays. There's 9 public holidays in the tax year January to December for the Republic of Ireland. We all know each one of them off by heart, I'm sure, at this stage. So just in relation to public holidays, employees other than part-time have an immediate entitlement to pay for a public holiday. Full-time employees can receive either a paid day off that day or within a month, an additional day of annual leave, or an additional day's pay. Part-time employees qualify for full entitlement if they have worked 40 hours in the 5 weeks prior to the public holiday. And in the situation where you have a part-time employee who doesn't normally work on the day a public holiday falls, the employee is entitled to 1/5 of their normal weekly wage for that public holiday. Just to look at an example there, we have Mary who works full-time Monday to Friday 9 to 5, and she wants to know what her entitlement is if she works on a bank holiday. So Mary works on the day the bank holiday falls. Okay, she's entitled to her day's pay for that day, and 2, she's entitled to a full paid day off within the month, or an additional day's pay, or an additional day's annual leave. We look at a second example there. John works part-time. So he works Tuesdays and Thursday evenings, 4 p.m. to 7 p.m. He wants to know what he's entitled to for the bank holiday, which falls on a Monday. So the bank holiday falling on the Monday is falling on a day that John doesn't normally work. So in this situation, generally he would qualify for 1/5 of his normal weekly rate as payment for the bank holiday. But given his hours, his 3 hours for 2 days a week, he hasn't worked more than 40 hours in the 5 weeks leading up to the bank holiday. So in this situation, he's actually not entitled to any payment for it.
Perfect. We'll move on. I see there are a lot of questions, and we will come to them. I suppose we'll just move on and finish up the presentation, and then we'll get to your questions, because I even know in advance there was questions around the public holidays as well. But I just want to touch on Sunday working. If you require an employee to work on a Sunday, it must be stated in their contract of employment that they are required to work on a Sunday. Second to that, that if you have an employee contracted to work on a Sunday, they must be compensated in some way. So an additional compensation in addition to their normal pay. So this compensation can be in the form of an added payment or time off in lieu. If there is a dispute in relation to the actual level of compensation being awarded, this will be heard in the WRC. And when it comes to, I suppose, determining what premium should be paid, an adjudicator will look at what is being paid in comparable employments. But I think it's important to note here that the compensation is generally an added payment or time off in lieu. There was a case that I've come across, and the name of it has just disappeared from my head, but basically it was a pub restaurant facility, and they had employees working on a Sunday, and they argued that the compensation for Sunday working was a free meal, and their Sunday dinner provided, and the court ruled that no, that wasn't actually sufficient compensation for Sunday working. It had to be an added payment or time off in lieu. And second to that, again, what we learned from previous tribunal cases in relation to that additional Sunday payment is that it must be specified and it must be clearly stated, ideally in your payslip, what the Sunday premium is. So it would be insufficient to say that your hourly rate is €12 per hour, and that is at that higher level because it includes the Sunday premium. That would be insufficient. They will want to see that Monday to Friday you are on X amount per hour, and then on a Sunday your premium is whatever. So they want to see specifics of where that is on the payslip. So I think most of the payroll software would highlight that, or would give you the facility to show that.
Yeah,
right?
well, both Thesaurus software and BrightPay would give you the facility to put through additional rates of pay, which would appear separately on the payslip, which in this case would cover the legislation.
Perfect. Yeah, so again, this was the point from the top there as well, that is ideally you should have it in the contract of employment if you're asking people to work on a Sunday as well. So again, coming close to the end there with night working. So night working is considered to be working between the hours of midnight and 7 a.m. So normally a night worker should not work more than an average of 8 hours in a 24-hour period. The average is calculated the average is calculated over a 2-month period generally. However, if your night working involves hazards or physical or mental strain, then you cannot use the average over the 2-month period, and it just must not exceed, working hours must not exceed the 8 hours in a 24-hour period. As an employer, if you are required to carry out a risk assessment in order to determine what hazards are there during night working, whether they be physical or mental strain, to establish what the maximum hours can be. And then finally, just on that, the organisation of working time doesn't account or make any accommodation for pay rates for night working. So very much pay rates for night working is left open and up to the employer. So again, that generally would be specified within your contract of employment if you were having night working. And again, you could illustrate that again on your pay slips as well. So just finally then to move to record keeping, because this really is a key point of the whole Act, and one of the final points is that employers must keep strong records with regard to their working time and their employees. So firstly, you have to include the name, address, job description, PPS number, your statement of terms and conditions. So this is essentially your employment contract. And if you had a WRC inspection, this is the information that they would look for. You also need to keep details of hours that people work, so their weekly hours worked, any annual leave that they took, and payment for any annual leave. And again, that would be shown on the payslip. How you treated public holidays, that you'll need to have records of that. And again, what we touched on earlier, you need to have a record of how you notified employees of their working hours, and whether that's a notice or emails or a roster that you put up on the employee notice board, but you have to have a record of that. In terms of how long you keep your records must be kept for up to 3 years. And we're talking again about the importance of this. It's a really key point to have your records in place. And failure to have them in place could see you with a fine of up to €1,900. And then we're also looking at the statement in terms of conditions. Failure to have them, as you're probably familiar, again, is 4 weeks pay per employee for not having a contract of employment in place. So, those fines could add up pretty quickly, and it's a simple step to get them in place, particularly if you've gone through all the hard work of, getting the steps in place and getting your payroll set up. So it's just a final step just to tidy them up, those pieces up. So that really brings our presentation section of today to a close, and I am eager to move over to our questions now to get answering them for you. So we'll just take a very tiny break till we get the questions set up. Perfect. We're just going through them now, but I see one coming in here that I'll just get started on. Do I have to pay employees for overtime work? This is a good question. It comes up a lot for us. Overtime is work generally done outside the normal working hours. There's actually no statutory obligation on employers to pay employees for work completed in overtime. However, many employers do actually pay higher rates for overtime. And generally what we would recommend is that your contract of employment clearly states that A, if you require employees to work overtime, and then B, if you do, what rates of pay will they receive? I suppose the key thing to remember is that if you have somebody working overtime, you need to ensure that their average earnings don't fall below the minimum wage, because then you've got a separate issue on your hand that they're not earning minimum wage. So in terms of the kind of Payment of Wages Act and things like that, that's the key concern is, are they receiving minimum wage? If they are, then there's no obligation on you to pay overtime. I suppose the question is, what's the best practice in your industry, in your company, and what's done? And then whatever you decide, that you put that in your contract of employment.
I'm just looking at a question here from Patricia. If someone is sick on certified sick leave since July 2015, are they accruing holidays still? They were working 2 to 3 days per week. I did mention that the Workplace Relations Act that came into effect on the 1st of August 2015. So basically prior to the 1st of August 2015, anybody on certified sick leave did not accrue holidays. So in this case, this particular employee, for that month that she was out sick in July, they wouldn't have accrued holidays, but from the 1st of August to now, or until they return, they will be accruing holidays at their normal calculation method.
Yeah, it was a big piece of legislation change that came in August. So it's certified sick leave. Again, that's generally long-term sick leave when we talk about certified leave. It can be a little bit tricky to get your head around, but this employee would be accruing annual leave, as Jenny rightly says. The thing is, she'll only be allowed to carry it over for 15 months. So let's say she went off in July. So let's say your annual leave year finished in December 2015. She will have 15 months from December 2015 to use that annual leave that she accrued, and after that, then she'll lose it or forgo it. Patricia, if you have any more questions on that, you can certainly drop us a line afterwards, and we can go into more specifics.
There's one there. If an employee gets a weekly shift allowance in addition to their regular pay, should this shift allowance be included in the gross pay for annual leave calculations? So yeah, the annual leave calculations will be based on your kind of normal regular hours plus any regular payments that you may receive. So you would have to include that shift allowance in looking at the calculation for the annual leave entitlement for that employee.
Just another one that's come in, that an employee has put in a request for leave for this Thursday to attend a family member's doctor's appointment. You don't have enough cover to allow this, but she wants to take the time anyway. The point here, I suppose, is it's whether an employee, whether their leave can be approved is very much up to the employer. So it's your position. You're allowed to decline leave if it doesn't suit you. So if you don't have cover, you're perfectly right, and you're in the right not to approve that particular leave. And then it could be it's a workaround from there. What's important, I would say, in this situation is that you have, again, an annual leave policy that clearly states that how employees must request their leave, what notice they must give, and again the position of the company that whether you approve leave or not is very much down to your business, dependent on your business needs and the busy periods, and it's totally in the employer's ability to not approve it or to reject leave if it doesn't suit. And once you ensure that the employee does take their full 20 days or whatever it is within the year, so that they do have access to take it. But if it doesn't suit you for this Thursday, yeah, you're perfectly within your rights to not approve that particular request.
I'm looking at one there. I use the Thesaurus payroll software. How do I put the extra pay for a bank holiday so it won't calculate bank holidays as worked hours? Kevin, there is a section in Thesaurus on your weekly or your monthly input called holiday pay. Now you can include the amount in there and record a note at the bottom of the payslip to state that it is payment for a bank holiday and maybe note the date. Or else you have the option of putting it through as an amount via a taxable addition in the additions and deductions section, and again just taking note of the date of the bank holiday and when it was paid for.
Are you okay there?
Yeah.
I just want to come in there quickly. Would it be possible to get notes of today? Absolutely. We record all our webinars and we send that out to all the attendees afterwards as well.
And just any questions that we don't get to kind of answer here, we will reply to everybody via email as well.
Yeah, there's quite a few questions.
Yeah.
Sunday pay there, can you pay the staff above minimum wage Monday to Sunday and give them an extra break and free dinner? I'm presuming that's for Sunday. I think that kind of is similar to the case that we talked about, and I would say no is the answer to that. Otherwise, again, if you're saying the premium for working on a Sunday is an extra break and a free dinner, we spoke earlier that it must be a monetary premium or time off in lieu of the day. So if you work a Sunday, then you get an extra day's annual leave during the next week or an extra days somewhere else. And if the only premium is that they're getting a dinner and extra time, you could find yourself in a court similar to that other case, Leopardstown Inn, I think it was. You could find yourself in a premium. And I know you're saying that you do pay them above minimum wage, but that there needs to specify what the Sunday premium is, not just for the whole week. So I maybe suggest that you have a review of that payment structure.
I'm not sure on this question. Can you tell me how to calculate holiday entitlement for a part-time worker who does not have a typical working week? She comes in when she's needed. I wanted to pay her 1/5 of weekly pay, but I have a problem with WRC officer. I'm not sure now, Katarzyna, if that's in relation to annual leave entitlement or public holiday entitlement. If it's the annual leave entitlement, probably the best method to calculate it there would be 8% of her total hours worked, and that will give you an accurate calculation of an hour's holiday entitlement.
Sorry, I'm seeing it on here and I'm counting up on my fingers with the question. If an employee works 7 hours, if an employee is working 7 hours and does not take their half-hour break by choice, can the employer pay the employee for the 30 minutes? The point here for me is, can the employees not take their break by choice? This really isn't a question of choice for the employee. The employee has to take their break, and it's the employer's responsibility. If you're seen not to be permitting that, I would really, there's no, it's similar to annual leave. You can't pay for annual leave and you can't pay people for their breaks. So I would tend to say no to that one, not to be paying for the break, and maybe trying to establish why that employee is not taking their break and really promoting that they do.
Kevin's asking, I have 2 employees going on maternity leave. How do I calculate holidays? Well, the calculation method is down to yourself, and I suppose down to how the employee is paid to date. But the employees on protected leave do still accrue their full entitlement to holidays. So if the employee is taking the statutory maternity leave of 26 weeks, you would be calculating their normal kind of holidays over that period as well. What I would just say there as well is if anybody has, kind of any questions, or we haven't answered the questions, or maybe we haven't read the questions the right way, what we'll do is we'll email the questions back to you. But if you want to get in contact with the support desk as well, just in case.
Yeah, sometimes when we read a question here, we don't take it the right way or as how you meant it. So please drop us a line afterwards if you need us to clarify anything. If you give a night shift allowance on top of an hourly rate, should that be included in the calculation of the holiday pay? Similar to that question we had earlier, I would say yes, if it's a regular night shift allowance. Again, and if you were calculating holiday pay over a specific an average period, then and night pay was a night shift allowance was part of that pay during that period, then yes, I would be including the shift allowance, because again, it comes back to the key fact that the employee shouldn't be in any way at a disadvantage by taking the annual leave.
An employee works a 3-day week but has overtime most weeks. Well, the legislation states that annual leave calculation is to include any regular bonus or allowance that does not vary in relation to work done but excludes any pay for overtime. So I would generally be going with whatever the normal kind of working week is there. But again, Anne, if you want to discuss that further, we can talk to you about that afterwards.
Yeah, and probably the same for this next question. What is the annual leave entitlement to uncertified sick leave of a full-time employee? I'm not sure if I'm reading that correctly, but if you have somebody who is off on, uncertified sick leave. So if they're uncertified, they're not accruing annual leave whilst they're out. So they wouldn't be accruing. But generally, uncertified sick leave is only for a very short period of time, a day here and a day there, and I think you'll find trying to take annual leave off that entitlement would be quite difficult to do using small percentages. But Lorraine, if you want to come, if you have a particular case there, come and drop us a line and we can maybe chat about that in more detail.
Can you award the 8% holiday entitlement every week? Again, could be picking this up wrong, Christy, but the legislation would be quite clear in the case that employees need to take their rest, and therefore they need to be paid for their holidays when they're actually, well, not when they're taking it, but it wouldn't be legislatively correct to just pay the employees a set amount every week for their holiday entitlement. They do need to take that time off. As far as
actually, if I understand what you're asking, is it okay to roll up the 8% pay in their weekly pay? And I would say no, that'd be hugely incorrect, and I wouldn't promote that practice. And if it is practice, I'd be kind of suggesting that it's reviewed. There's some kind of specific, quite long questions, and they're quite specific, and they're difficult to answer in this environment, so we might come back to some of those people as well. Sorry, apologies for the delay, we're just reading as we go. If an employee, I'm just reading this one, if some employees are on 1 to 2 days a week, is it a legal requirement that they have a contract in place? And if they haven't, how much is the fine? Yeah, all your employees should have a contract in place, regardless really of how many hours they work, and whether they're part-time, whether they're part-time, full-time, there's no difference in that regard. So I would definitely have a contract in place for somebody who works 1 or 2 days a week, definitely. Because there are different types of contracts as well. If you're somebody that just works kind of on an ad hoc basis as well, more than casual, and you don't know the exact hours, again, I'd have a contract for them. It'd be maybe a slightly different contract. And the fine for not having your contract in place is 4 weeks pay per employee. And the question reads, and is this fine per employee or single amount of fine on the employer? It's per employee, the fine. So it's 4 weeks pay per employee. So, that fine, if you have 6 employees, 10 employees, that fine could rack up quite quickly.
Somebody's asking, we said the session is recorded. So basically the session has been recorded, and at some point today it will be emailed out to all the participants who registered. So hopefully by the end of the day that will actually go out.
Maybe tomorrow.
Possibly tomorrow. It depends on the phones.
There's another question, and we've got time for a few more. Are part-time employees entitled to all the public holidays over the Christmas period, Christmas Day, Stevenson's Day and New Year's Day, or does the 40 hours worked, just reading the end of the question, over the previous one, start again. No, they are entitled to them, all those bank holidays, if they work the 40 hours. I'm reading quickly. Are you suggesting that you might have to start a new 5-hour period in the new year?
In the new year, I think that's how I would read that as well.
And no, the question, regardless, it's kind of it'll flow over the 2 years, because some companies' annual leave might be March to April. So if an employee has worked 48 hours in the previous 5 weeks, they'll be entitled to a fifth of their pay, or the compensation for all the bank holidays over Christmas. You read that the same as I am?
Yes, no, I am. Yeah, definitely. Is there a maximum of holidays accrued in one yearly period allowed to be carried over into the next yearly period? I think generally the rule of thumb is that kind of anything over the statutory amount, it has to be agreed to basically by both parties. Like if the employee requests to carry across leave, the employer is at their discretion to say no, and they might have to take them before the end of the
within a certain
year.
period.
Yeah.
Generally, kind of the legislation is at 6 months that you would have it. I kind of personally would probably say 3 months because you really want to promote that people take their annual leave. There's no maximum set, but again, in my experience, it's generally quite low because again, it's the employer's responsibility that employees would take their holidays during the year. But yeah, they can, with agreement from both sides, carry over leave. And again, this is something that really should be specified in your annual leave policy, because again, it'll set a consistent approach for all employees. So in your policy, once you kind of consider what works for your company, a lot of companies would say, only in exceptional circumstances will we allow people to carry over leave. And you're talking about maybe somebody who's getting married or having a baby or something, a major like that they would only allow it to carry over in those circumstances. And then also in your annual leave, you're specifically stating when it must be taken by. So whether it's within 3 months or 6 months, anything over 6 months, I wouldn't really permit it or allow it.
Can you change the method of calculating holiday pay mid-term? I think I'd have to know a bit more of the kind of background of the circumstances to that one. So I can contact you directly about that afterwards, Christy.
Just another one there. Can an employer, it's kind of another controversial one, I suppose, can an employer pay overtime rates for some employees and not for others? It's a controversial one. I don't want to say too much on it. I suppose you probably can, but to be very careful, I suppose. Ultimately, your overtime rates are stated in your contract of employment, and like anything, every employee's contracts can differ. They can say certain things, but what I'd be particularly looking out for here is who are the parties that you're paying different overtime rates for. If, for example, that you're paying double time or a certain rate for full-time employees when they work overtime, but then for part-time employees you're not, well then that's a clear discrimination there, because part-time employees are not allowed to be treated in any way less favourably to their full-time counterparts. So that'll be something I can be concerned about. Whether you're paying different rates for different people in different areas of the business, there may be a valid argument as to yes, that might be permitted. But again, if there's any suggestion that it's kind of an unfavourable treatment to any one particular group, such as whether it's women or part-time workers or students, then questions would be raised there.
Lorraine has just come in with a question there with regard to contracts. How do you launch the Bright Contracts on Thesaurus? So Bright Contracts is a separate program that Thesaurus have created. So if you actually log on to the website, brightcontracts.ie, you can download the software directly and it'll appear as a separate icon on your desktop to Thesaurus. But there is a facility once you download Bright Contracts to actually create the company and import the employees directly from Thesaurus. So that's a huge advantage to having both packages that you can import directly from it, and that will cut out a massive amount of input time from the Bright Contracts setup. I think that's all the questions so far, but what we'll do is we'll review.
Yeah, as I said, they're coming in thick and fast. We're trying to read them, so we may have skipped over a couple, I don't know. Hopefully we got to most of them, and hopefully we answered them correctly. But if you've got any further questions, drop us a line afterwards and we can get to them, or if there's any ones that we see that we've missed, we'll come back to you as well. I hope you found today useful and informative. Other than that, I think we're all done. So thank you very much for attending, and we will we'll send you on the recording either today or tomorrow, and that you can have a look over in your free time. So thank you all very much.
Thank you.
And we'll see you again.